In a significant development in India's legal landscape, the Supreme Court of India, on April 17, 2025, paused the implementation of certain controversial provisions of the Waqf Amendment Act 2025, following a heated legal battle over its constitutional validity. The centre, represented by Solicitor General Tushar Mehta, assured the apex court that no Waqf properties, including those recognized as Waqf by user, would be denotified, and no non-Muslim appointments would be made to the Central Waqf Council or State Waqf Boards until the next hearing scheduled for May 5, 2025. This interim order, passed by a three-judge bench led by Chief Justice of India CJI Sanjeev Khanna, alongside Justices Sanjay Kumar and K.V. Vishwanathan, has sparked widespread debate with implications for property rights, religious autonomy, and governance of Waqf institutions. This article delves into the intricacies of the Supreme Court's decision, the provisions under scrutiny, the arguments presented, and the broader socio-political context surrounding the Waqf Act. The Waqf Act governs the administration of Waqf properties in India, which are endowments made by Muslims for religious, charitable, or pious purposes. These properties, managed by Waqf boards and the Central Waqf Council, include mosques, dargahas, graveyards, and other assets dedicated to community welfare. The Waqf Act, originally enacted in 1954 and significantly amended in 1995 and 2013, has been a subject of contention due to disputes over property classification, mismanagement, and legal challenges to its provisions. The Waqf Amendment Act 2025, passed by the Lok Sabha on April 3, 2025, with 288 votes in favor and 232 against, and later cleared by the Rajya Sabha after a 12-hour debate, introduced sweeping changes to the existing framework. The bill, which received presidential assent on April 5 and came into force on April 8, 2025, aimed to enhance transparency and accountability in Waqf management, but faced criticism for allegedly infringing on religious autonomy and property rights. Over 70 petitions, filed by parliamentarians, religious organizations and political parties, including the All India Majlis-e-Ittihadul Muslimin (AIMIM), the All India Muslim Personal Law Board (AMPLB), and Congress MPs, challenged the constitutional validity of the new law, prompting the Supreme Court's intervention. The Supreme Court flagged three primary aspects of the Waqf Amendment Act 2025, which have become the focal points of the ongoing legal discourse. 1. Waqf by user. The concept of Waqf by user refers to properties that have been used for Muslim religious or charitable purposes for an extended period, even if they are not formally registered as Waqf. This practice, legally recognized through court rulings and incorporated into the Waqf Amendment Act 2013, allows such properties to be deemed Waqf based on historical usage. The 2025 Act, however, restricts this by requiring that only a practicing Muslim of at least 5 years, who is the legal owner of the property, can declare it as Waqf. Petitioners argued that this change effectively nullifies the concept of Waqf by user, potentially leading to the denotification of numerous properties, including those recognized by courts, such as in the landmark 2019 Ayodhya judgment. The Supreme Court expressed concern that the new provision could undermine properties already declared as Waqf by user under the 1995 Act. CJI Khanna emphasized that the legislature cannot rewrite history by reversing the status of properties recognized by courts, stating, "Long-standing Waqfs cannot be undone by new legislature." The centre's assurance that no Waqf properties, including those under Waqf by user, would be denotified until May 5, 2025, was recorded to maintain the status quo and prevent irreversible changes during the judicial review. 2. Non-Muslim representation on Waqf boards and council. One of the most contentious amendments in the 2025 Act is the inclusion of non-Muslims in the Central Waqf Council and State Waqf Boards. Unlike the 1995 Act, which mandated that members such as MPs, MLAs, and State Bar Council representatives be Muslims, the new law allows non-Muslims to occupy key positions, including the chairperson, ex officio members, and professionals in fields like business management or social work. Critics argued that this could reduce Muslim representation to a minority, with only 8 out of 22 members in the Waqf Council and 4 out of 11 in State Waqf Boards guaranteed to be Muslims. Petitioners, including AIMIM leader Asaduddin Owaisi, contended that this provision violates Articles 26b, 26c, and 26d of the Constitution, which guarantee a community's right to manage its religious affairs, own and acquire property, and administer it according to law. Congress leader Abhishek Singhvi likened the scenario to a Hindu temple board or Sikh Gurdwara committee dominated by non-members of the respective faiths, calling it retaliation in the guise of reform. The Supreme Court questioned the centre's rationale, with CJI Khanna asking, "Are you suggesting that minorities, including Muslims, should also be included in boards managing Hindu religious institutions?" The centre's assurance to halt non-Muslim appointments until the next hearing reflects the court's intent to scrutinize this provision further. 3. Powers of District Collectors. The 2025 Act grants district collectors significant authority to determine the status of disputed Waqf properties. If a collector identifies a property currently used as Waqf as government land, it ceases to be Waqf until a court resolves the dispute. This provision, stemming from Section 3C of the Act, raised alarms among petitioners, who argued that it could lead to premature denotification of Waqf properties, even those recognized by courts. The Supreme Court noted that this power could disrupt the status of Waqf by user properties, which constitute a significant portion of Waqf assets in India. The court warned that such authority risks altering the character of properties before judicial determination, potentially infringing on property rights. While the centre assured that the character or status of Waqf properties would not be changed until May 5, 2025, the court indicated it might consider staying this provision in future hearings to prevent misuse. Supreme Court's interim order and centre's response. On April 17, 2025, the Supreme Court heard a batch of 72 petitions challenging the Waqf Amendment Act 2025, alongside petitions questioning the 1995 and 2013 acts. To streamline the process, the court directed that only 5 lead petitions, collectively titled In Re Waqf Amendment Act 2025, would be considered, with others treated as disposed of or segregated for separate listing. The bench granted the centre 7 days to file a detailed affidavit defending the 2025 Act, with petitioners allowed 5 days to respond. The court's order recorded the centre's assurances, articulated by Solicitor General Tushar Mehta, that no Waqf properties, including those declared or registered as Waqf by user, would be denotified or have their character changed until May 5, 2025. No appointments would be made to the Central Waqf Council or State Waqf Boards under the amended Sections 9 and 14, which allow non-Muslim representation. Mehta urged the court against issuing an interim stay, arguing that the 2025 Act was a considered piece of legislation, following extensive consultations, including 38 sittings of a joint parliamentary committee and 98.2 lakh representations. He emphasized that the government needed time to present documents, statutes, and reports to justify the amendments, warning that a stay would be a serious and harsh step without complete judicial assistance. The court, while refraining from a formal stay, accepted the centre's assurances to maintain the status quo, with CJI Khanna noting, "The situation as is prevailing today should continue so as not to affect the rights of the parties." Socio-political context and reactions. The Waqf Amendment Act 2025 has been a lightning rod for political and religious discourse. The Bharatiya Janata Party, BJP, which spearheaded the legislation, argues that it brings transparency and benefits poor and backward Muslims by addressing mismanagement in Waqf properties. Union Minority Affairs Minister Kiren Rijiju, defending the bill, stated that it unites all Muslim sects and dismissed allegations of dividing the community, emphasizing India's secular ethos. Opposition parties including Congress, Samajwadi Party and DMK have hailed the Supreme Court's interim order as a victory for constitutional values. Congress MP Imran Pratap Garhi called it a win for the constitution, while Samajwadi Party MP Zia-ur-Rahman expressed hope for justice. Critics including Kerala's Waqf Minister V. Abdurrahman warned that the act could lead to a bulldozer raj on Waqf properties, with disputes potentially used to demolish assets. Advocate Hari Shankar Jain, involved in related cases like Gyanvapi, demanded the repeal of sections from both the 1995 and 2025 acts, alleging misuse by Waqf boards to claim public and Hindu temple lands. Public sentiment, as reflected in posts on X, is polarized. Some users celebrated the Supreme Court's intervention, viewing it as a safeguard against hasty changes, while others supported the amendments, citing the need for reform in Waqf governance. The debate has also reignited discussions on secularism, with the court's question about non-Muslims on Hindu boards prompting broader reflections on religious representation in institutional management. Legal and constitutional implications. The Supreme Court's scrutiny of the Waqf Amendment Act 2025 raises critical questions about the balance between legislative authority and judicial oversight. The court's reluctance to issue a formal stay aligns with the principle that legislation is rarely stayed at a preliminary stage. However, its insistence on maintaining the status quo underscores the need to protect property and religious rights pending a thorough review. The challenges to the Act invoke Articles 14, Equality, 25, Freedom of Religion, and 26, religious autonomy of the Constitution, setting the stage for a landmark judgment on the interplay between state intervention and community rights. The inclusion of non-Muslims in Waqf governance tests the boundaries of Article 26, which guarantees religious denominations the right to manage their affairs. The powers granted to district collectors also raise concerns about due process and the potential for administrative overreach, particularly in light of historical disputes over Waqf properties. The concept of Waqf by user, deeply rooted in Islamic jurisprudence and Indian legal precedent, underscores the tension between modern legislative reforms and traditional practices. Conclusion. The Supreme Court's decision to pause key provisions of the Waqf Amendment Act 2025 and the Centre's assurances mark a critical juncture in India's legal and religious landscape. By addressing concerns over Waqf by user, non-Muslim representation and collectors' powers, the court has signaled its commitment to safeguarding constitutional rights while allowing the government an opportunity to justify its reforms. As the case progresses, it will test the delicate balance between modern governance and religious autonomy, with far-reaching consequences for India's pluralistic society. The nation watches closely as the judiciary navigates this complex terrain, with the next hearing on May 5, 2025, poised to shape the future of Waqf administration in India.